Criminal procedure and the constitutional rights of U.S. citizens. Police interrogations and confessions resulting from police interrogations can be analysed under due process, Fourth Amendment, Fifth Amendment and Sixth Amendment, and may be protected, and they may be thrown out for various reasons. Under the due process clause, the main question is whether the person's rights to a fair trial were violated here, and whether the confession was voluntary or whether it was coerced, forced by the police against the wishes of the individual. A confession that is coerced, that is involuntary, is inadmissible in court for all purposes. Under the Fourth Amendment really applies to searches and seizures. So how can a police interrogation, confession be affected and challenged under Fourth Amendment? Well, if the confession was the fruit of an unlawful search or seizure, then under the fruit of the poisonous tree doctrine, it can be inadmissible because of the prior unlawful search or seizure and the direct connection between that and the following confession. The Fifth Amendment, however, has a direct on-point effect on the confession, in that the individual has a right to remain silent and to not be forced to act as witness against themselves, also has a right under Miranda interpretation of the Fifth Amendment to counsel to support them in that. So if there is a Fifth Amendment violation, then the interrogation and the results of the interrogation can be, and the confession can be, inadmissible. The Sixth Amendment, as we will learn, is a right to counsel, a right to a lawyer, and the lawyer to act as the intermediary to the individual and be available at the interrogations and other critical stages in the prosecution of the individual. They have a right to counsel. If that is violated, again, the confession can be thrown out as inadmissible. The exclusionary rule applies to all U.S. Constitution violations, but the scope varies. So a coerced confession that violates due process is inadmissible for all purposes. A confession that's made in violation of Miranda and the Fifth Amendment is inadmissible, except for impeachment. It can be introduced to impeach the witness. And the Sixth Amendment is the same situation. A confession made without counsel following charges is inadmissible, but it can be used to impeach. In the due process area, the question of the interrogation and the admissibility of the confession was whether it was a violation of due process sufficient to prevent a fair trial of the individual. And there are several factors are considered. Is there a fair risk that the confession was false? The courts look at the totality of the circumstances, including the police conduct, the vulnerability of the person that made the confession, whether counsel was present, the person was represented by counsel, whether it was made in the presence or absence of friends and other people providing support, and was the individual told he had the right to remain silent. These are factors that have traditionally been used to consider whether a confession was voluntary or coerced. There is a test of admissibility provided by Wigmore when looking at interrogators, and he asks whether the interrogators care if the confession was true, and whether they offered threat or promises or fear or hope to the individual in making the confession, in really the third area is looking at, was the confession voluntary or not? So in violating due process, actually, it's a pretty hard case to win the violation of due process, because you have to show that there was a fair risk that the confession was false and that this actually prevented the individual from receiving a fair trial. Under the Fifth Amendment, an individual cannot be compelled in any criminal case to be a witness against himself. And the idea here is that their own thoughts and memories are protected. As many convicted individuals were made confessions without being aware of their rights to remain silent, and the court in the Miranda versus Arizona case forced the police to issue the warnings to the individual, informing them of their rights before then making recording confessions and interrogating the individual. So there are exceptions. An individual, if they are immunized, if the court gives them immunity from prosecution, then they can be forced to provide evidence against themselves. And it can be a case of criminal contempt if they then refuse to speak. But generally, without immunization, U.S. law cannot compel an individual to act as a witness against himself. So there are 4 components to the Miranda rights, and the police should read all 4. Even though an individual says, okay, I know my rights, the police should read all 4 in order to then have subsequent confessions admissible. And the rights are, 1, to remain silent. If they speak, this evidence is admissible. That's the second piece of information they're provided with. The third thing is that they're told that they can have the right to an attorney. And fourthly, that if they can't afford an attorney, then attorney will be provided for them for free. Miranda applies to custodial interrogations by the government when the rights are not waived. So, as you'll see, we're going to look at custodial interrogations, and in that situation, before a confession can be made admissible, Miranda rights, all 4 rights, should be read to the accused. What the Miranda rights actually mean is that you do not have to talk to the police, and you can't be punished or prejudiced for refusing to talk to the police and answer their questions. If you start to speak to the police, you can terminate the interrogation at any time, and that also you have a right to an attorney, and the right to the attorney is available immediately, even if you can't afford one. You have a right to the attorney at the custodial interrogations by the police. You don't have to wait until the court case or trial. You have a right to an attorney immediately, even if you can't afford one. Miranda applies at custodial interrogation. So one of the first inquiries we need to make is this custodial? And a custodial interrogation is initiated by the police. And it's the situation where a reasonable person would believe that their freedom of movement was restricted. So if the person was in handcuffs or in a police car, locked in a police car or in a police room, and the atmosphere surrounding them, if there were threats or number of officers surrounding them, all these factors can be taken into consideration when looking at whether the interrogation was custodial. A Terry stop is not custodial. Although the person is held for several minutes for questioning, they are not in custody. Therefore, Miranda rights are not necessary in a Terry stop situation. If the Terry stop situation moves to one where the individual is handcuffed, then that is considered to be custodial and Miranda rights are necessary at that point. Situations like in a probation office is not considered custodial, so Miranda rights are not necessary when an individual is questioned in a probation office. However, in jail, it is considered custodial, so Miranda rights are necessary. Other situations like misdemeanor traffic stops, they are considered custodial, so Miranda rights do have to be issued to individuals that are stopped for misdemeanor traffic stops. And for health inspectors, school officials, and questioning in those types of situations, it really depends on the circumstances as to whether the interrogation is considered custodial. They will look to the duration, the physical atmosphere, the place, whether the person was allowed to leave, and so on. The second inquiry in a Miranda case is whether the police conduct raises to the level of interrogation. And so interrogation has been found by the Supreme Court to apply not only to express questioning directly to the person, but also to words or actions on the part of the police that they should know were reasonably likely to elicit an incriminating response. So, for example, when the police put a suspect in the back of the police car and then proceeded to drive down the road, and the two police officers in the front of the car spoke to each other, saying they wouldn't want a child to find the gun, for example, this was considered interrogatory, as it was likely to elicit a response, and it did elicit a response from the individual suspect in the back of the car, who then took them to the place where he'd left the gun. So the interrogation extends beyond mere direct questioning, and it's where the police are likely to elicit an incriminating response. A volunteered confession is not considered an interrogation. If an individual approaches a police officer and immediately confesses to a crime, this is not considered an interrogation. Miranda applies to government actors, such as the police, FBI, drug enforcement agencies, and so on. Also to government actors in state schools, for example. And so Miranda is required in those situations where an individual is talking to a person representing the state or federal government, or other city governments, and so on. Store shoplifting security individuals that question a person are not government, therefore they do not have to issue Miranda warnings in that situation. When an individual waives their Miranda rights, they waive both the right to the lawyer and the right to remain silent. We'll see later they don't waive the rights to a lawyer post charges, because that right is then triggered and attached under the Sixth Amendment. But a person waiving their rights under Miranda can waive the rights to both the lawyer and the right to remain silent. And the burden is on the government, the police here, to prove that the waiver was voluntary and knowing. And this is totally subjective, as it requires us to look inside the head of the person waiving the rights and to determine that they knew they had rights before they waived them. Silence of the individual is not enough. The waiver does not have to be in writing, but there has to be sufficient evidence, and a waiver is not presumed. That is proved by a preponderance of the evidence, and the burden is on the government to prove that the waiver was voluntary and knowing. Miranda rights to essentially remain silent have to be asserted. This is very different from Fourth Amendment and Sixth Amendment right to counsel. And recently the courts have held in considering a case where it wasn't clear if the individual was actually asserting their Miranda rights or not. The court has held that the invocation of the Miranda rights must be unequivocal, and it also must be timely. Only when interrogation is imminent can the Miranda rights be asserted. So, in order to assert the rights, the individual need only say, I need to speak to a lawyer, or I have nothing to say right now. So, there are two rights here mainly provided under Miranda. One is to remain silent, and in order to assert that, all the individual need to say is, I don't want to talk to you about this, or something similar. And to the right to counsel, the individual must say, I want a lawyer. Of course, it's better if they can say, I hereby invoke my Miranda rights as broadly as possible, but most individuals are not aware of that. But an unequivocal statement that is made when interrogation is imminent, that the person wishes to remain silent or wishes to remain a lawyer, wishes to have a lawyer, is sufficient to assert Miranda rights. Under Miranda, the police have to issue the 4 Miranda warnings before they request information, evidence from the individual. You have the right to remain silent. If you do speak, your words can be used against you in court. You have the right to a lawyer. If you don't have the funds, and a lawyer can be appointed for you. So, in an emergency situation, for example, where the police are stopping an individual in a public place, like a store, and they detain the individual, the police have a right in this type of emergency situation, as a public safety exception, to ask the accused, where's the gun? If the gun may be a source of potential injury to the public. So there is a public safety exception, where's the gun, where's the kidnapped victim, in exigent circumstances. And this allows information, confessions, evidence produced by the individual following without a Miranda warning to be admissible in court. It's an exception to the general rule. The motivation of the individual officer is not controlling here. So the court will look at the situation, the emergency, the public safety issues, and determine if the statement made in absence of Miranda is then admissible. What about confessions that are made in violation of Miranda? Well, involuntary confessions, those that are coerced by the police, can't be used for any purpose. They can't be used for impeachment. They're actually violations of due process as well as Miranda. So involuntary confessions in violation of Miranda are inadmissible for any purpose. However, voluntary confessions in violation of Miranda, they are generally inadmissible. They're suppressed as evidence of guilt, but they can be used to impeach the witness, the person, to prove that they're lying. So voluntary confessions in violation of Miranda can be admitted as evidence in order to impeach. When an individual asserts their Miranda rights, the police may be being interviewed by different police and different stations, different agencies for different crimes. How does the assertion of Miranda rights cross crimes? Well, it really depends on which right the individual asserts. If the individual says, I want a lawyer, then the police have to stop questioning, and they can't question that individual again until the lawyer is present. And this applies to all crimes. So if the individual has requested a lawyer, they're being questioned for several crimes, then the questioning must stop, and subsequent questioning on other crimes by other police officers in other stations, for example, is also inadmissible until the lawyer is provided. If the Miranda rights asserted are the right to remain silent, so instead of requesting for a lawyer, the individual merely says, I wish to stop speaking about this, or I wish to remain silent, then if the individual is maybe taken to another station and interviewed by different officers about a different crime, then the confession there can be admitted. So when the individual says they wish to remain silent about one crime, if there's a if there's then some break in time, and a different interview takes place about another crime, the original request to remain silent does not apply, and the subsequent confession is admissible in this case. So it really depends on how the individual asserts their Miranda rights. If they don't assert the right to a lawyer, then they can be questioned on other crimes, in other situations, and in other conditions, and the admissions and confessions about other crimes can be admissible. When the accused asserts their Miranda rights, the options open to the police are somewhat limited. If the person requests an attorney, then they cannot reinitiate the interrogation until the attorney is present. Or they could wait for the accused to reinitiate the discussion themselves. The police cannot reinitiate until they have that attorney present. Everything stops. As soon as the individual says, I want an attorney, the police have to stop and then provide the attorney before the discussions can continue. As mentioned on the previous slide, if the individual merely wants to remain silent on this crime and they don't request an attorney, there are possibilities for the police to question the individual about other unrelated crimes separately, and that information could be admissible. Miranda requires a custodial interrogation. So in order to question an individual and have evidence and confessions admitted as evidence without issuing a Miranda warning, then the police can hold non-custodial interrogations of the individual. So for it not to be custodial, the reasonable person would believe that they are free to leave and they are not prevented from moving around and leaving the interrogation by the police. So the police, in order to circumvent Miranda and have Miranda-less confessions admissible, can hold non-custodial interviews. And again, the test will be whether a reasonable person believes they were free to leave. Now, there was a case where an individual was made a confession before being issued with Miranda warnings. Then the individual was given their Miranda warnings and then repeated the confession. And this was allowed by the court under those circumstances, and the confession was allowed to be admissible. Well, following this case, the police then started to do this as a matter of practice. They would interview the individual in a custodial setting. They would have a custodial interrogation without Miranda. The individual then confesses. Then the police Miranda and ask the individual for the confession again. And the second confession was much smoother. It's sort of been rehearsed. And so this was a very effective technique for the police. However, the court cut this off. They said this was a deliberate ploy to threaten and thwart Miranda. So this practice has been stopped. So the question first, confession, Miranda, and second confession is no longer allowed by the Supreme Court, and evidence obtained in this way will be excluded and inadmissible. Criminal procedure and the constitutional rights of U.S. citizens.